welcome everyone for this SSLT. We're really delighted to host Professor Prince Saprai from UCL this afternoon, this evening. I think many of us colleagues are familiar with Prince and his work in contract and legal theory, private law theory more generally. I myself, I found it quite inspired and inspirational in many senses, and I benefited a lot from reading Prince's work, including his book on contract law without foundations, which is a sort of a pluralist take on contract theory. This evening, Prince will speak to us on this topic, trust in promise and contract, one sense or two. I think it's fascinating that Prince starts off by looking at what some might see as the leading work in contract theory in the last sort of half century, Charles Fried's Contract as Promise. And I think it's fascinating because Professor Fried, for some of us who have come across his work or his teachings, he also ran an online course for a mass audience. And the title of this course was actually called From Trust to Promise to Contract. And so the sort of three elements there, trust and promise and contract, came across to Professor Fried as exhibiting some sort of a tight connection or a neat logic that I think is worthy of further exploration. And Prince does that via engagement with Fried's interlocutors, including Dory Kimmel, and looking at whether these connections between these concepts can be loosened somewhat, so to speak, and how they sort of interplay, right? So I won't say any more, and we are looking forward to what Prince has to say and our discussion thereafter. So over to you.
Thank you, Zhongxing, and thank you, James, for inviting me. It's great to be here at NUS. I've had many colleagues and friends go to NUS and work here, and this is my first time visiting NUS in particular, and that's fantastic. So this paper, so as you said, I published this book in 2019, Contract Law Without Foundations, and one of the claims I made in the book is that at the heart of contract is something I called trust-based cooperation, which I regard as the value of contract, if you like. But I didn't defend that claim very much in the book. As you said, kind of my focus was trying to argue for the idea that in order to properly understand contract law, you have to rely on a multiplicity of values and principles. But I did say this thing about trust-based cooperation being very important, at least with regards to certain systems of contract law, like you find in America and in England. And in recent years, I've kind of gone back to that claim, and I've been working on a set of papers, really, of which this is the first. And I've got other papers on good faith and interpretation, and the connection between contract law and the common good. And they're all really looking at this idea that at the heart of contract is this value, which I call trust-based cooperation, for want of a better phrase, and kind of exploring that in different ways. So on to this paper. So trust in promise and contract, one sense or two. So the paper starts with Fried, and Fried makes this very tight connection, very well-known connection between promise and contract, saying that promise is, and I quote, the moral basis of contract law. And by that, he meant that promise sheds light on contract law's key doctrines and provides the area of law with some unity. That value provides that area of law with some unity. And that led to what's become known as the contract and promise debate, which was basically a debate about the extent to which promise does and should inform contract law rules and doctrines. And there have been many distinguished contributions to that debate, including James has wrote a very important paper contributing to that debate. But one thing I found reading a lot of that literature is that although there's a lot of focus on Fried's claim that the basis of contract is promise, less attention, substantially less attention was given to another claim that Fried makes in his book, which is that contracts invoke trust. And that's important because not every account of promise is trust-based. So you could have accounts of promise which are based on the value of assurance. So Tim Scanlon gives such an account. Reliance, famously Atiyah and Grant Gilmore argued that promise is best understood in terms of reliance. Authority, so David Owens has argued that promise serves an authority interest. So there are different conceptions of promise. And Fried was committed to a particular conception which emphasized that at the heart of promise was trust. And therefore, given he thought that contracts are promises, at the heart of contract must also be trust, hence the, as you said, the logical links between the three notions. Now, there is one very important exception in the literature, I think, and that's Dori Kimmel's book in 2003, From Promise to Contract, which does have something to say about Fried's claim that trust is central to promise and contract. And Kimmel agrees with that claim. He thinks that trust is important in promise and contract, but he diverges from Fried in a very important way, because he says that there are different species of trust in promise and contract. So in contract, he says trust is thin and based on legal enforceability, whereas in promise, trust is thick and based on trust which emerges out of pre-existing relationships. And therefore, he says, the two practices diverge fundamentally in terms of their nature, methods, and aims. So what Kimmel did, and this was kind of central to his book, was to try and loosen some of the very tight connections that Fried had made between promises and contracts. And so this paper goes back to that debate about the role that trust plays in promise and contract, that debate between Kimmel and Fried, and argues that although Kimmel was right to recognize the importance of trust to contract, I'm doubtful about his claim that there are two different senses of trust at play in promise and contract. And instead, I defend Fried's original claim that the sense of trust in promise and contract is the same. I defend his monist view over Kimmel's dualist picture, if you like. So I'll start by saying a bit more about Fried's claim, Fried's monism about promise and contract when it comes to trust. So Fried had this view that promising is an autonomy-enhancing, socially beneficial convention. So in that way, he kind of agreed with David Hume. So Fried says, so when you make a promise, you commit yourself to help another person, the promisee, pursue their goals. So you make the pursuit of the promisee's goals part of your own end. And when promises are exchanged, as they are typically with contracts, then the gains become reciprocal. So he says famously, oh, brilliant. Thank you. So he represents that schematically in this way. He says, you want to accomplish purpose A and I want to accomplish purpose B. Neither of us can succeed without the cooperation of the other. Thus, I want to be able to commit myself to help you achieve A so that you will commit yourself to help me achieve B. And in that way, contracts use promises to enhance the autonomy of both parties. And crucial to the success of contract as an autonomy-enhancing device, Fried argues, is promise, because promise invokes morality to achieve that autonomy-enhancing end. So, next quote. Fried says, when my confidence in your assistance derives from my conviction that you will do what is right, not just what is prudent, then I trust you. And trust becomes a powerful tool for our working our mutual wills in the world. The reason trust is important for Fried is that he says if contract was just based on calculations of self-interest, that wouldn't provide the kind of security you need for contract to be autonomy promoting. It wouldn't, because calculations of self-interest might change from the moment when you make a promise to when it becomes the time for performance. And that's an insight that lies behind the efficient breach theory that the economists have long given when it comes to contract. And that's in contrast to morality. So with morality, when morality is invoked through promise, that will always require the keeping of a promise, even when it becomes inexpedient to do so. So that gives you the kind of security you need to promote, for contract to promote autonomy. Moreover, this was a separate claim. So on this view, promise and trust are important for achieving the instrumental aims of contract to promote autonomy. But quite apart from that, Fried says, so remarkable a tool is trust that in the end we pursue it for its own sake. We prefer doing things cooperatively when we might have relied on fear or interest or worked alone. So he says it's not just the case that it promotes autonomy, the autonomy of the parties, but also or serves an instrumental function of promoting the autonomy of the parties, but it's also intrinsically valuable in and of itself to cooperate with people on the basis of of trust. So trust is central to Freed's account of both the instrumental and intrinsic benefits of the practice of contract. And Freed says a promissory duty arises when the promissor has, and I quote, intentionally invoked a convention whose function it is to give grounds, moral grounds, for another to expect the promised performance. So Freed's view is when you make a promise, you freely invite the promisee to trust you. If the promisee then accepts the promise, it's then an abuse of trust for you not to perform. And because contracts are promises, contracts must be, on Freed's view, and again, this kind of follows logically from his view, it invokes the same kind of trust that promises do. So that's kind of Freed's basic picture of the kind of relationship between trust, promise, contract. On to Kimmel. So Kimmel, as I said, has a dualist view about trust in promise and contract. So Kimmel's book was a response to Freed's claim that contract mirrors promise. And Kimmel argues that's an oversimplification. And it's an oversimplification because of the different background circumstances in which the two practices operate. And the different contexts in which the two practices operate leads, Kimmel argues, to a divergence in the methods, aims, and values that underpin the two practices. So the context in which they operate is very important for Kimmel. And he argues that the central difference between the contexts or the background circumstances in which the two practices operate is that promises are normally made between close relations, whereas contracts are normally made between strangers. And a lot hangs on this word normally. It's not really clear what Kimmel means by normally, but I think it could mean one of two things. So one, he could mean statistically common, the context in which most contracts and most promises are made, or he could mean logically primary. And by logically primary, I mean that you have to understand the context in order to understand the main point of each practice. I think he's making both of those claims, but it's not altogether clear. And these contexts have implications, Kimmel argues, for the kinds of trust that each practice employs. So let's start with promise. So with promise, Kimmel argues normally that promises are made in the context or against the background circumstances of pre-existing trust between the parties. And promises provide a form of, what he calls special reassurance provide special assurance between people who are in pre-existing relationships with one another. But to achieve that, to provide the special reassurance that they do, they have to invoke pre-existing trust that arises from the pre-existing relationship. So Kimmel says, this type of trust, it is the kind of trust which is likely to be the product of some previous acquaintance with the person or based on some more or less informed impression of her personality. So basically, because you know something about the other person, you're in a relationship with them, that's the basis for the trust that you're you're invoking. So notice the difference here with Fried, because Fried is saying, regardless of any background relationship you have, when you make a promise, you invoke a convention and you invite the promisee to trust. But the promisee could be anyone. It doesn't have to be someone who you're in a pre-existing relationship with. So on Kimmel's view, promises between strangers are abnormal, or a derivative type of promise. And he thinks that this context, the context of pre-existing trust, explains the core functions of promising. And on his view, there are two. So one is an instrumental function, and he agrees with Fried that promises promote autonomy instrumentally. But also they serve, Kimmel argues, an intrinsic function. And the intrinsic function is that of promoting the special relations between the parties by manifesting attitudes of trust and respect between them. So another quote. The promise
Love the picture.
is to invoke trust, Kimmel says, on the promisee's part. To take the promise seriously as intended is normally to give that trust, to show that it exists. That word "show" is important. And to keep the promise is to justify the promisee's trust, to prove trustworthy, and again, to show respect. Promises are intrinsically valuable, if you like, as an exercise in the deployment of trust and respect in the framework of the relationship between promisor and promisee. So you kind of convey attitudes when of trust and respect through the process of making, accepting, performing promises, which consolidate, if you like, the relationships between the parties. But that manifestation, that showing of trust and respect, is only possible, Kimmel says, and I quote, when these attitudes are in fact, or at least are believed to be, behind the participants' actions and reactions, close quote. So there's a risk, on Kimmel's view, posed to the expression of those attitudes of trust and respect when other motives are at play for accepting or performing promises. And promise as a practice, Kimmel argues, is designed to ensure that there is transparency of motives between the parties. And he says it ensures transparency of motives by having because there are no systematic social sanctions attached to the breaking of a promise by the practice of making and keeping promises. And systematic does work for Kimmel there. So he thinks promise involves this kind of thick trust, pre-existing trust between the parties. Now, contract is different, because contract, Kimmel says, or contracts are typically made between strangers in the absence of pre-existing trust. And in the contractual context, it's legal enforcement rather than the pre-existing relationship, which provides a substitute source of reassurance for the promisee. And Kimmel says, so contract involves not the kind of thick trust that we find in the context of promises, but what he calls trivial trust, which is different to profound or thick trust, such as you find in promises, which sees the promisor in a in a certain favorable light due to knowledge of the promisor's character or personality. But rather, in contract, the trust is thin and is based on the promisor's capacity, Kimmel says, for basic rationality. What he means by that is that in contract, breach of contract is generally, in most cases, an irrational thing to do, because you won't benefit from breach because you'll have to pay expectation damages to the promisee. And therefore, the transparency of motives that you find in the practice of making and keeping promises doesn't exist in the context of contract. And that's because of the presence of legal enforceability. So, last quote, legal enforceability casts a thick and all-encompassing veil over the motives and the attitudes towards each other attributable to parties to contracts, thus leaving reliance, performance, and other aspects of contractual conduct largely devoid of expressive content. So you can't express these motives of trust and respect in contract because the expressive significance of acceptance and performance is lost in contract due to the reliance on legal enforceability. So as far as the promisor is concerned, the promisee is only accepting the promise because, or they might think that promisee is only accepting the promise because they know the courts will enforce it. And the promisee might think that the promisor is only performing their promise because it would be irrational for them not to perform. And so as a result of this, Kimmel says, contract can't promote the kind of attachment that promise promotes, but rather promotes what he calls a diametrically opposed value, the value of a detachment, which he says is the value of being free from relationships to get stuff done, which he thinks is a valuable option for people to have in their lives. So all my paper does, so those are the two views, is just express some views, some doubts about Kimmel's dualism and to provide a defense of Freed's view. So I'm skeptical that there are two senses of trust between contract and promise. And I think Kimmel draws a false contrast between the two practices. And I make two main arguments. So the first one is that I'm not sure that trust in promise is normally thick or profound in the way that Kimmel seems to think. And I've got 3 reasons for that in the paper. So, sorry, 2 main reasons for that in the paper. So I find the claim implausible, and I find it implausible regardless of which way you read the use of the word normally in Kimmel's view. So if you read it empirically, his claim that most of the time promises are made within the context of pre-existing relations, I have a problem with that because, firstly, because he doesn't cite any empirical evidence for that claim. And secondly, I'm not sure how easy it would be to obtain such evidence because it's very difficult in the context of pre-existing relations to distinguish between statements of intention between people from promises. So I might say, I might not always use the phrase, I promise. I might just say, I will definitely be at the party tonight to my friend. Now, am I there making a promise, or am I just stating a firm intention to go to the party? It's not altogether clear. So it's hard to know how you would count if how many promises are made in these contexts. Now, of course, you could read the claim normatively, but I have a problem with reading it normatively too. So remember, on the normative reading, it's impossible to grasp the point of the practice without understanding that the practice is designed to achieve its functions in the particular context of pre-existing relations. My problem with that is that the practice of pre-existing relations seems, sorry, the context of pre-existing relations seems least in need of the practice of promising. Why do I say that? Well, firstly, it seems unnecessary in the context. Promising seems unnecessary in the context of pre-existing relations, because if you already, normally unnecessary, let's put it that way, if you already trust someone, then you can count on their statements of intention. So if my wife says she'll pick up the kids, I know she'll do that because I trust her, and I don't need her to promise that she's going to pick up the kids. Secondly, it's arguably insulting to make promises in the context of pre-existing relations. So if my wife says she'll pick up the kids and I say, but do you promise? She'd probably, I know she would, she might take offense. So my request there would suggest a lack of pre-existing trust, rather than, on Kimmel's view, indicate that such trust is present in the relationship. Rather, it seems to me that promises are made in the context of such relations when further reassurance on some matter is required. So they could perform a kind of signaling function to make the promisor aware of the importance of a particular matter. So if my daughter was to say to me, will you promise to be at this summer concert, might be that, you know, it's very important to her that I attend, and so she just wants to indicate that to me. They might fill a gap where there's an absence or a lack of trust on a particular matter. So remember, the presence of thick trust doesn't mean that trust is absolute. Usually when you trust people, you trust them to do X, Y, and Z. You don't trust them across the board. So for example, I might trust my friend to take me to a good restaurant, not to gossip about me, keep my secrets, but I don't trust him to water my plants. So, you know, like all of us, my friend is not trustworthy in all things. And so you might ask a friend to make promises where you lack pre-existing trust in relation to a particular matter. And another way in which promises might be made or are made in the context of pre-existing relations is where there's been a breakdown of trust on a particular matter. So my friend might fail to keep a secret. And so because of that failure, because of that breach, if I'm going to tell him a secret again, I will ask him to promise to keep it, and by accepting his promise, I offer him an opportunity to rehabilitate himself for breaking, for breaching trust in the first time. But if you notice, the common thread between these cases, signaling cases, cases where there's a lack of trust on a particular matter, or cases where promises being used to rebuild, where there's a breakdown of trust, the common thread is that there's an absence of trust or a lack of trust. It's not, these are cases where trust is missing, and that's why you need to make the promise. And this, I think, chimes with the monist view that promise is, Freed's view, that promise is a freely given invitation to trust. Rather than promises being made on the basis of the existence of pre-existing trust. So recall, just on Freed's picture, promise is made, you invite someone to trust you. If they do, if they repose trust, you then have a duty not to betray them. And the source of the promise's confidence that you will perform is the moral obligation to perform, as opposed to any knowledge of the promisor's personality or character. It's the fact that you've undertaken a moral obligation which is the source of their confidence that you will perform. The other claim I make, so the first claim is, I don't think trust in promise is normally thick. The other claim I make in the paper is that I don't think trust in contract is normally thin. So recall, Kimmel says that contracts typically take place between strangers, and they do. He's right about that. But he says, therefore, because they normally take place between strangers, the parties rely on legal enforceability for reassurance rather than pre-existing trust. But the problem with relying on legal enforceability is that, according to Kimmel, that clouds out the expression of motives on which close relations depend, in contrast to promise, where there is transparency of motives and attitudes of trust and respect between the promisor and promisee can be conveyed. Now, I have two problems with that claim, that trust is in contract is normally thin because of legal enforceability. First of all, I don't think it's a type of trust. So he calls it trivial trust. So he thinks of it as a species of trust. But I don't think it's trust, because for me, and I take this view from Freed, and I think Freed's right about this, trust goes beyond predicting behavior. So just to give you an example, I might believe that my wife will remain faithful to me because she relies on me financially. But I don't think we'd say that the fact that I can predict that she'll remain faithful means that I trust her. But that's exactly, I think, what Kimmel's view entails, because you can predict how someone's going to behave. That is a source of trust. My view, and it's Freed's view, is that trust exists where the source of one's confidence is the reasons upon which another person will act. So I will trust my wife to be faithful if my reason for that confidence is that she loves me. So it's grounded in the reasons upon which someone may or may not perform an action in the future. That doesn't, though, mean that there's no trust in contract. Rather, the trust in contract is the same type of trust that we find in promise on Freed's view. It's moral trust. It's trust or confidence that the promisor will perform the moral obligation that they've undertaken. Secondly, I don't buy the idea that because of legal enforceability, that clouds out, again, this is Kimmel's view, the expression of motives or of attitudes of trust and respect between the parties. So Kimmel's argument is that the motives are clouded out in the context of acceptance of promises or contracts and their performance, but there are a host of other ways in which contracts might express trust. So just to go through a handful. So when you enter into a contract, you might signal how seriously you take a promise. So, for example, getting married might be an indication of how seriously you take a promise. When you choose who to contract with, so for example, if I sell my house to a loving couple rather than a property developer, that might be an expression of trust. What terms you contract on, so you might insert an express duty to perform a contract in good faith. How you perform, you might go above and beyond what the contract requires, and that might be an expression of respect for the promisee. Through renegotiating or waiving contract rights where they're difficult for the other party to perform, that also might be an expression of respect or trust. So I think Kimmel's focus is too narrow just to focus on performance and acceptance. But even there, I'm not sure that the expression of motives of trust and respect is scrambled in the way that he claims that it is. And so in the paper, I make an analogy with murder. So murder carries a life sentence. In my country, I'm sure it does here too. But that doesn't mean that most people don't murder due to the threat of the sanction. I think most people don't murder because it's a heinous and evil thing to do. So similarly, in contract, why can't we think of the sanction as a backup for those people who might be tempted to break their promise? Doesn't mean that because of the presence of the sanction that there's no trust in contract. I don't fully defend the monistic picture, so that in my paper, but I do think it's attractive. So just to conclude, on my view, Kimmel is wrong, or I doubt his claim that trust in promise is thick and trust in contract is thin. Rather, I think there's the same kind of trust in both practices, and it's what I call moral trust. And I think this view has several advantages. So one, it doesn't make the implausible claim that promises between strangers are abnormal or derivative. Secondly, it explains why when promises are made within the context of ongoing relations, they're normally it explains why promises within the context of ongoing relations are normally unnecessary and often insulting. It explains why promises nevertheless, though, play a significant role. I would disagree with Kimmel that they're kind of normal in personal relations, but they do play an important role in personal relations. But it's usually when there's an absence of pre-existing trust. They provide additional assurance when there's an absence of pre-existing trust. Fourth, it explains the sense in which there is a breach of trust at stake, even when contracts are made between strangers. In contrast to Kimmel's view, according to which only trivial trust is at stake in the context of contracts between strangers. And as I've argued, that's not a form of trust. And finally, I think the monist picture is perfectly compatible with the existence of remedies for breach of contract, as long as you see them as a backstop, in the same way that a life sentence is a backstop for the crime of murder. So the dualist picture, I think, distorts the nature, function, and values that underpin promise and contract. I haven't in the paper defended monism fully. As I said, I'm kind of writing a set of papers which seek to defend it from different perspectives, but I hope I've done enough to explain the basic contours of the view and why I think it paints a more appealing picture of the nature or role that trust plays in promise and contract than Kimmel's dualist view does.